Sahaj Vidhi www.sahajvidhi.in Question 1. Discuss the right of the state parties to formulate reservations to a treaty under the Vienna Convention on the Law of Treaties, 1969. What are the legal effects of such reservations? Explain. Model answer. Right of state parties to formulate reservations under VCLT, 1969. The Vienna Convention on the Law of Treaties, VCLT, 1969, is the foundational instrument governing treaties between states. It recognizes the right of states to formulate reservations to treaties, which is crucial for promoting wider participation in multilateral agreements. A reservation is defined in Article 2(1)d of the VCLT as a unilateral statement, however phrased or named, made by a state when signing, ratifying, accepting, approving or acceding to a treaty, whereby it purports to exclude or to modify the legal effect of certain provisions of the treaty in their application to that state. The purpose of allowing reservations is to provide flexibility. It enables states to become parties to a treaty even if have objections to specific provisions, rather than being forced to reject the entire treaty. This flexibility helps achieve broader adherence to international legal instruments. Permissibility of reservations. Article 19 VCLT. However, the right to make reservations is not absolute. Article 19 of the VCLT sets out the conditions under which a state may formulate a reservation. 1. The reservation is not prohibited by the treaty itself. 2. The treaty provides that only specified reservations, which do not include the reservation in question, may be made. 3. In cases not falling under A or B, the reservation is not incompatible with the object and purpose of the treaty. This is a critical criterion, ensuring that reservations do not undermine the fundamental goals or essential integrity of the treaty. Acceptance of an objection to reservations. Articles 20-23 VCLT. For a reservation to be effective, it generally needs to be accepted by other contracting states. The VCLT outlines different scenarios. Expressly authorized reservations do not require subsequent acceptance by other contracting states unless the treaty so provides. Treaties with limited parties are constituent instruments of international organizations. A reservation requires acceptance by all the parties, for limited parties, or by the competent organ of the organization. For constituent instruments, other cases, a reservation is considered accepted by a state if it has not objected to it within 12 months after being notified of the reservation, or by the date on which it expressed its consent to be bound by the treaty, whichever is later. Legal effects of reservations. Article 21 VCLT. The VCLT provides a nuanced framework for the legal effects of reservations, which vary depending on whether other states accept or object to them. 1. Between the reserving state and an accepting state, the treaty enters into force between them. The provisions to which the reservation relates are modified or excluded to the extent of the reservation in their mutual relations. The reservation modifies these provisions for the other party in its relations with the reserving state, and vice versa, reciprocal effect. 2. Between the reserving state and an objecting state, simple objection. If a state objects to a reservation but does not oppose the entry into force of the treaty between itself and the reserving state, the treaty enters into force between them. However, the provisions to which the reservation relates do not apply as between the two states to the extent of the reservation. This means the specific provision is effectively nullified in their bilateral relationship, but the rest of the treaty remains in force. 3. Between the reserving state and an objecting state, qualified objection. If a state objects to a reservation and expressly states that it considers the treaty not to be in force between itself and the reserving state, then the treaty does not enter into force between these two states. This is a stronger form of objection, effectively preventing any treaty relationship from forming between them. 4. Between other contracting states, a reservation does not modify the provisions of the treaty for the other contracting states in their relations inter se, among themselves. Their treaty relations remain unaffected by the reservation. In essence, reservations create a complex web of bilateral relationships within a multilateral treaty, allowing states to tailor their obligations while maintaining the overall integrity of the treaty for those who accept it fully. The VCLT aims to balance the desire for universal participation with the need to preserve the object and purpose of treaties. Please visit our website www.sahajvidhi.in for more content.